Good morning, everyone. A warm welcome to all of you. On behalf of Indian Business and Professional Council, I welcome all the guests and members who are joining us today for this webinar. To start with the session, I welcome Mr. Suresh Kumar, Chairman IBPC, for the opening remarks. Thank you.
Dear members and distinguished guests, greetings and welcome to all of you to this important webinar. It's a discussion on some of the more recent and path-breaking reforms in the UAE, both on the social, legal, and as would benefit the business and professional community across the economic segments and across the resident population in the UAE. These will have tremendous impact. I think, to the leadership in the UAE for proactively reviewing and very sensitively calibrating these reform processes. These are all well-researched. There's a lot of homework that goes behind them before the government in the UAE, whether it's the federal government or whether it's the government of Dubai, announce reform and important initiatives such as these. I must compliment Mr. Naveen Sharma for putting together an eminent expertise panel to discuss these. And without further ado, let me invite Mr. Naveen Sharma to conduct the proceedings. Thank you all.
Good morning, sir. We are thankful to our chairman who has come and addressed us. It is his suggestion that we should cover this year a brief summary of the law. There are a number of laws have come this year which has changed the way the businesses are being conducted in Dubai and in the UAE. We all are aware that the VAT law is now mature. It is the third year we are going to complete by end of this month. On top of it, there is a VAT in Oman has come. Then we have the ultimate beneficiary. Social side, there is a number of changes have come up. And ESR. ESR is also the starting of a tax regime, which we say the OECD. The framework is global in nature, but implementation is happening all around. There is a cutoff date of December 31st where all the business have to report. Portal is now up and running. Today, this is a very special meeting. A special meeting in a sense that these laws is not only applicable to the SMEs, professionals, but the knowledge of these law has become very basic. Dubai is a business city. In this city, everybody is somehow or the other related with the establishments. Either they are running their own business or they are associated in providing the service. I'm thankful to all the speakers, panelists, and this meeting is not possible without my colleague in the steering committee, Mr. Manu. Mr. Manu is a fellow chartered accountant. He is founder and CEO and partner of Emirates Chartered Accountant Group. He is a speaker, which you can see if you will go to the YouTube, you will see that how popular is he. He is on the television, on the radio all the time. He has 20 years of experience in the field of finance, accounts, audit, taxation, and management consultancy. He started his career in Dubai in the year 2003. He is a speaker and he has spoken to various platforms in an international sphere on topics like VAT, economy substance, international taxation. He is a member of IBPC, AAA group, our group, and also the auditor of ICAI. And I will now invite him to come and take the proceedings of the meeting further.
Hi, good morning. Hi, thank you very much, Mr. Naveen Sharma, for that wonderful introduction. Good morning, Salam Alaikum and Namaste. I thank IBPC for giving this wonderful opportunity for coordinating this special event, and special thanks to Naveen Sharma, the convener of AAA Focus Group of IBPC. I welcome all IBPC members, guests, and speakers to this special event, UAE's groundbreaking economic legal reforms 2020. Greek philosopher Heraclitus said, change is the only constant. He would have been definitely amazed if he were able to see the changes, what is happening in UAE right now. The changes happening in the business field are enormous in the UAE. It is a responsibility of IBPC AAA Focus Group to bring those changes to you. It's not possible for us to bring all the topics at a stretch at a time in front of you in one session. We have selected some of the recent changes which are very relevant for the businessmen in the UAE. Subject experts will share their views how those changes will impact the business in the UAE. The event is scheduled for 2 hours and is divided into 2 parts. The part first, 6 speakers are there who will be sharing their views on different topics, how this will impact the business in the UAE. And part 2, it's a panel discussion on a very interesting topic. New changes in the law affecting social life in the UAE, covering inheritance law, marriage law, fine on public indecency, attempt to suicide, consensual sex, and more. Without any further delay, let me proceed. The first speaker. The first topic we are going to cover is an evergreen topic, nothing other than UAE VAT law, my favorite subject. There are many changes happened recently in VAT. Latest VAT updates, let us see what a business owner should know now. Let us hear it from Mr. Ankur Jain. Just to give you a brief about the speaker, Ankur Jain. Ankur Jain is a chartered accountant and a company secretary by profession. Currently the director at MMJS Consulting, leading the indirect tax division. He has previously worked with Deloitte India, Deloitte Malaysia, and KPMG UAE, possesses over 13 years of experience in that field, the tax field. He is a regular speaker at different forums and events providing insights on VAT and excise tax. My friend Ankur Jain, the platform is yours. Please come on. Please come on.
Thank you very much, Manu, for the kind words and a very detailed introduction. I would welcome everyone to this webinar, and good morning, everyone. I will just quickly share my screen and will take you through the updates. Yes, and hope I think everybody is able to see my screen. Yeah. So as Manu said that the only thing which is which is changing ever, it is the VAT law. There are a lot of things, lot of development which has happened under the VAT law in UAE. So if you see on my screen, just as you say, a very high level overview of what has happened in the last 3 years under the UAE VAT law. So post implementation, post 1st of January 2018. If you see, there has been 22 public clarification which the FTA has released. In addition to that, there are 28 VAT user guides, 12 e-learnings, and in addition to that, numerous private clarifications which have been issued by the authorities. What it sums all that there is lot which is happening under the UAE VAT. The authorities are understanding there are new transactions which are coming, so there are not lot more new clarifications which are coming from the authorities. So it is again very, very important for businesses to understand. So today I'll be sharing some of these important clarifications or changes which the authorities has done. So to start with, the most important change which is important for every business in UAE is very recently the UAE Supreme Court has issued its first judgment on VAT law. This is very, very important judgment which has been pronounced by the Honorable Supreme Court of UAE. What it says. So if you must be aware that businesses were filing voluntary disclosure then when they were aware that there is any underpayment of tax or any missed transaction where the tax impact is more than 10,000 dirhams. So you have to file a voluntary disclosure. And when you file a voluntary disclosure, there were two types of penalties. One was the late payment penalties, another was the VD penalties. I'll not go into detail, but these two penalties were there, and lot of businesses, they started litigating, and at the lower forums they were getting favorable judgment where the lower courts were understanding and they were giving judgment in favor of the businesses that in case you are filing a voluntary disclosure, two penalties cannot be applicable. And if voluntary disclosure penalty is applicable, the late payment penalties are applicable, they should be applicable from the date when the voluntary disclosure is filed. However, in mid of October, this Supreme Court judgment came in where the Supreme Court has clearly mentioned, they mentioned that voluntary disclosure are just the branch of the original return. It is just mere amendment to the original return. What it means? It means that whenever you are filing a voluntary disclosure, it would be termed as you are just amending your original return, which means the penalties would be applicable from the date of the original returns. Just to give you an example, so if you identify any error in a return which you have filed for period January 2018, and if you identify right now and you do a voluntary disclosure, by this Supreme Court judgment, there would be a late payment penalties which may go up to, in this case, go up to 300%. And with this judgment, this would be staying. So it's again very, very important for the business to understand this judgment and the penalties which would be applicable in case of filing of voluntary disclosures. Going ahead, I would now be covering some of the very, very important amendments and clarification which has been issued by the FTA. So if you see on my screen, the next one is VAT P19 public clarification on export of services. So here the FTA has recently also amended the law. In a nutshell, when you're doing an export of services, previously what we used to do, all businesses, what they used to do is they just used to identify if we are doing an export of services and the service recipient is outside UAE, then we can treat that as an export of services. We just need to see that whether they don't have presence and they are outside UAE. However, now with this new clarification and amendment in the law, the zero rating on export of services has become very, very narrow. So if you see, there are two conditions which needs to be fulfilled in full. One is, whenever you are doing an export of services, you need to understand that the recipient should not have any place of residence in UAE, which means that they should not have any fixed establishment in UAE. Secondly, at the time when the services are performed, at that time also, there should not be any person from the recipient who is in UAE. This condition is very, very critical. And there is an amendment also which has been made to this condition where the FTA has clarified that in case a person is in UAE for more than a month and if he is related with the supply when the services are performed, then condition 2 would not be fulfilled and export of services would not be provided. Just to give you one more example here is that we have seen a lot of businesses who operate from UAE as a global, shared service center, or there are a lot of, directors on the board of UAE entity, which also manages operation for wider Africa region or EMA region. All those, by virtue of this amendment to the export of services rules, these needs to be revalidated, rechecked, because the export of services provisions have become really, really strict. And every businesses need to understand whether these two conditions are fulfilled in substance. In that scenario only, the export of services would be allowed. Again, a very, very important clarification which the Federal Tax Authority has issued on VAT. The clarification number is VAT Public Clarification number 17. It is in relation to availment of input tax credit. So VAT Public Clarification number 17 has clearly mentioned to avail input tax credit, each business has to ensure two conditions are fulfilled. Condition number 1, you should have received the tax invoice from the supplier. Condition number 2, either you have made the payment or there is an internal approval in your organization to initiate the payment, which means that there is an intention to make payment. So only then these two conditions, where you have received the invoice and there is an intention to make payment, then only you can claim the credit. We have seen a lot of businesses not completely aware of these two conditions. So it is very, very critical for each business to understand that only credit would be allowed if these two conditions are fulfilled. In addition to that, what happens in case these two conditions are fulfilled later on? The FTA has clarified that in case these conditions are fulfilled later on, then you need to file a voluntary disclosure and claim the credit. What is another thing which is very, very important, which businesses are not fully aware, that what happens if I don't make payment to my supplier, whether I need to reverse the input tax credit? The answer to that is yes. There is a provision under UAE VAT law which clearly mention that in case you don't make a payment to the supplier within 6 months from the agreed date of payment, then you need to reverse the input tax credit. Just to give you an example, in case in your business, if you have a 60 days credit period and plus 6 months, so 60 days plus 6 months, if you don't make payment even after 8 months to your supplier, then you are required to reverse the input tax credit. You may have a question in your mind, what happens if when you make the payment? If you make the payment subsequently, then you can again take the credit. But this is a point when in each FTA audit, the FTA auditor is asking. So again, a very, very important amendment and very, very important thing which businesses should be aware of. Next is reimbursement and disbursement. Again, there is a lot of issues about the transactions, whether it will fall into a reimbursement and disbursement. The FTA has issued a clarification number 13, where they have clearly mentioned that in case any transaction which needs to be classified as disbursement, all the 5 conditions should be fulfilled, then only VAT is not applicable. In case it is not classified as a disbursement, then it would be considered as a reimbursement, and reimbursement VAT needs to be applicable. So again, very, very important for businesses to understand that transactions fall into a category of disbursement or reimbursement. In case they fall into disbursement, they need to ensure all the conditions of VAT public clarification number 13 needs to be fulfilled. Without taking much time, I'll quickly also update businesses about a scheme which the FTA has, which is known as an administrative exception. We understand that a lot of businesses, they have issued tax invoices, they issued tax credit note, but due to their system issues, the tax invoice and tax credit notes are not compliant. What they can do now? There is a scheme where if they go to the FTA and present the case that what is the reason why they cannot fulfill the conditions as mentioned in the law, which needs to be applied on the tax invoice and the tax credit note. If you give the reason, then the FTA can give you an exception. And if FTA gives you the exception, then whatever format which the FTA has approved can be applied and can be correct. So again, a very, very important thing which businesses needs to ensure, because just to give you an example, in case your tax invoice or tax credit note format is incorrect, there may be an administrative fine of 5,000 dirham for each tax invoice and each tax credit note. So very, very important for businesses to seek exception against the administrative exception rule. And the last, which I'll be talking about, what happens now. So we have seen that 3 years VAT has been there in the country. What happens next? So the next step which the authorities will do is the FTA audit, which will commence. Some of the businesses have already got notices and they have started, their audits have started, but most likely for more business, we go into the next year, more audit will come. So what needs to be done? So if you see what is this process, on a very high level basis, the FTA will give you a notice. Normally an email comes where you need to provide a reply within 5 business days. Again, very, very important. Your processes should be robust enough to provide the information in 5 business days. Then you need to share the information to the authorities. They can request for further information. If they are satisfied, it is okay. If they are not satisfied, they can also visit the premises. They can visit the premises and do a detailed audit. And finally, they will give you a decision. So this is a complete overview of the FTA audit process. A lot of details are asked by the authorities. But before giving it to my next speaker, I will just ask all the businesses to just go through the entire process. The slides which I'll be sharing, where we have gone into detail and discussed about the probable information which the authorities will ask, because this would be the next step where most of the businesses would be audited next year by the FTA, and they need to ensure that before the authorities come, they are aware of what are the things they need to provide to information to the authorities, and there are less fines and less penalties, if any. So with this, thank you so much, and I'll be sharing back to Manu to invite the next speaker for the day. Thank you very much.
Thank you. Thank you so much, Shango. That was a very nice presentation, Chris. And what is important, that only spoken and well within the time limit. So now the second most important, one of the most important topics is economic substance regulation in the UAE. Very relevant topic right now because the due date is nearing to us. Only 19 days left. 31st December 2020, the due date. And in between, holidays also coming. So we have to hurry up. Let us know the brief about the economic substance regulation. What step we have to do now? What businessmen should do now? So for that, the speaker is none other than myself. So I would like to share the screen. Please give me a few seconds. Hi, everyone. Economic substance regulation is a new regulation introduced in the year 2019, applicable for the year 2019. But there were some changes in the regulation. One regulation was issued last year. Change was totally, that law was replaced by another new regulation, that is the UAE Cabinet of Ministers Resolution number 57 of 2020 with the ministerial decision number 100 of 2020. I'm not going in detail through the regulation, but I am giving you in brief what are the important steps we have to do now, or we have to look into now as a businessman. First point is that you have to check whether regulation is applicable for you or not. In order to know whether the regulation is applicable for you, you have to check how your business structure is, whether your entity, whether you are running the business as a legal person or not, whether it is a legal person or natural person. You have to check if the law is applicable only for a legal person. That means for a company like LLC, public limited companies, and all this kind of companies. So the regulation is not applicable for individuals, sole establishments, trust foundations. The regulation is not applicable. Number two, if your business is in the nature of a company as a legal person, then check what's the nature of your business activity. The law is not applicable for all activities. It's not, there are a lot of different types of business in the UAE, but those are, this regulation is not applicable for all companies. It is applicable only for companies which are conducting relevant activities. What are the relevant activities? There are 9 specific activities are considered in the regulation as relevant activities: banking, insurance, investment fund management, lease finance, headquarters, holding company, shipping company, intellectual property business, and distribution and service center business. Distribution and service center business includes trading and service sectors. So activity wise and what we discussed in detail, this is 11th hour. This is not the time to learn in detail the law. We have to know what step we have to do now. Just giving you a brief due date, and of course the penalty is there in every regulation. Why I'm highlighting the penalty here? Because the due date is nearing to us. The portal, we have to submit the in Ministry of Finance portal, the form economic substance notification and economic substance reports we have to submit in a Ministry of Finance portal. The due date, if your financial year on specific year, maybe 31st December on any year, then you have to submit the notification within 6 months, report within 12 months. That is as per the regulation. If you don't submit the notification on time, 20,000 penalty, and report if you don't do within 12 months, then penalty is 50,000. If any wrong information is filed, 50,000 is the penalty. And now I'll give you one of the most important due dates, which is extended now. That's why the due dates are coming to 31st December 2020. The notification has to be submitted within 6 months, but at the same time, if your financial year is 31st December 2019, 6 months already expired, but you might have submitted the economic substance notification already to your licensing authority or regulatory authority, but we have to resubmit now because the portal is opened in Ministry of Finance. So if your financial year is ending 31st December 2019, file the notification before 31st December 2020 in the Ministry of Finance portal and submit the economic substance report also before 31st December 2020. Now, there are some companies which are following different financial years. Some companies financial year may end 31st January or 29th March of 29th February of 2020. 31st March of 2020. So different dates will be there. So any company which is having different financial year end, which is maybe up to June, if anything is coming as a financial year end, still you have to submit the notification before December this year, 31st of December this year. But you have 1 year time to submit the report from the end of the financial year. So important point is, any company which are having financial year 31st December 2019 or 31st March, January 2020, February 29th or 2020 or 31st March, anything, due date for notification is December 31st, 2020, only 19 days left, and report can be submitted within 1 year from the completion of the financial year. For any entity which are having financial year 31st July 2020 or thereafter, take your 6 months time for filing the notification and 1 year for filing the return. So this is the brief of the extension of the due date. Now, as a businessman, what you have to give importance is that there are many things which you have to comply with. That means the purpose of the regulation is whether company is meeting the economic substance test, whether company is doing the business in the UAE or not. That is the test which we have to conduct. Now, I'll give you a brief of the bullet points which the economic substance notification reports are looking for in the case of managing a business in the UAE. It is very important. Check your records in the year 2019. How many number of board meetings you done in 2019? Whether how many number of board meetings held in the UAE? Whether quorum of directors are physically present in the UAE. You may be having a practice of meeting over any of the social, any of the virtual platforms. No, physical presence is important. With the minimum quorum, strategic decisions should be taken in the UAE itself. Whether all the board meetings minutes are prepared or not, and whether you kept these records in the UAE or not. Does the board of directors have necessary knowledge and expertise to conduct this business or not? All this information has to be filed to the authority through the report. So in the year 2019, check whether you were complying these requirements or not. If you were not complying these requirements, a negative report will be going to the authority, which even authority may report to the international body as well. So we have to ensure that you are conducting the business, managing the business by sitting in the UAE itself. That report we have to submit to the authority. Another important aspect, even importance for the financial statements. It is important. We have to submit the financial statements to the authority. Can be unaudited as well, but it has to be in accordance with international financial reporting standards. So the total revenue, total income, operating expenditure, expense for relevant activity, tangible assets list, details, and the reportable period, the profit or loss which you had for that reportable period, all this information has to be uploaded to the authority in the form. And there are some licenses which are exempted. So I'm not going in detail through the exempted license. Anyway, for exempted licenses also, we have to submit the notification, but report need not be submitted. So what I suggest, instead of going through the regulation in detail, I suggest the businessman should do the action point like this. Check whether your business is a legal entity or not, whether it is a company or not. If you are a sole establishment, the regulation is not applicable for you. If you are doing business as an individual, the law is not applicable for you. The law is applicable only if you are a company. Next one, are you conducting a relevant activity in the UAE? Check whether your company is doing relevant activity. I listed 9 relevant activities, whether you are conducting any one of those relevant activity or multiple relevant activities. Then check what is your financial year end. Check your memoranda if you are not, if you are having some SME, small entities, if you are not regularly doing the auditing in mainland and some of the authority that audit is not mandatory as of now. So whether check your financial year as per your legal documents, specifically in the memorandum of association, and submit the economic substance notification before the due date. Because if you don't submit the notification before the due date, the penalty is 20,000 dirhams. And check the management of the company is performed in the UAE itself or not. I explained you in detail whether the board meetings are conducted in UAE, physical presence with minimum quorum is there or not, minutes are maintained in the UAE or not, whether activities managed from the UAE itself or not. Check that was complied with or not. Next one, all administrative activities or aspects are met or not, like whether you have minimum employees in the UAE to conduct the relevant activity, whether they are sufficiently qualified, they are having experience or not, whether you have sufficient office space in UAE, and whether you have sufficient physical assets for making the operation or doing the operation, whether you have incurred sufficient expenses in the UAE. All this have to be checked and complied with in accordance with the regulation. And now identify the parent company, ultimate parent company, and the ultimate beneficial owner. All this legal structure you have to identify and report to the authority, and prepare the financial statements in accordance with the international financial reporting standards. If it is audited, that is well and good, because after auditing, then you will make sure that on completion of the audit, the financial statement is true and fair view. Their auditor will be certifying that it's a true and fair view, their view. So you can make sure that the financial statement is correct, so there won't be any change in the reporting. So if any change is there in the reporting next year, if you're changing the financial or wrong information is gone in the economic substance reports, then there will be penalties. So to avoid those, make sure that you are complying with the regulations. Take these action points now, only 19 days left. So what I suggest, you will be having your internal team to experts to manage this. So get their advice or get an expert to submit the economic substance regulation, economic substance regulations notification and economic substance reporting before the due date. That's my humble request. So hope everybody will be able to submit their economic substance regulations reports and notification within the due date. So with this, my session is over on economic substance regulation. Now I would like to go for the next session. So the topic, so the next session is very interesting session. There's a third topic which we are going to cover here. So it's an important topic for the business community as well as for individuals in the UAE. We were eagerly waiting for years to get this regulation. So what is that? Changes in the bankruptcy and insolvency laws. How this impact the individuals and business. That's the topic we have chosen here. We have an eminent speaker here. The speaker for the session is Ms. Diana Hamadi. Ms. Diana Hamadi is a UAE licensed lawyer with right of audience before UAE courts and founder of Diana Hamadi Attorneys at Law in Dubai. Is a boutique firm, a law firm specializing in cross-border litigation and private health. She adorned significant feathers on her cap. She was ranked by Chambers ranked band one high net worth individual in the United Arab Emirates 2020 and the most influential female lawyer in the UAE by Thomson Reuters. Best Legal Affairs Authors by National and the Arab Woman Award of the Legal Chapter 2018 by ITP. Wow! Miss Diana Hamadi, we are very lucky to get you in this platform. So please help me to welcome Ms. Diana Hamadi to give her view on this new regulation, the amended regulation. Madam, the platform is yours.
Thank you, Manu. Good morning to everyone. Thank you very much for spending your Saturday morning with us. I'm sure everybody has that question about the business culture of the UAE. Witnessing this shift in less than 3 years is amazing for our generation, because what we are seeing now is a shift from a country, a business culture that rendered whoever got into trouble, into debts of a business, unfit to continue to remain. As a lawyer with the experience of 15 years, not really comparable by many of the lawyers who have been here for 30 to 45 to 50 years, maybe I gave that advice to a couple of clients who would come complaining about debts in their business to leave the country. But now the advice is completely different with the shift that we have managed, luckily, to witness. Now we are helping businesses go through the difficulties that they are facing through 2 laws and not one. Not necessarily businesses in that aspect, but we have a bankruptcy law and we have an insolvency law. To many, that would be confusing because what we are used to as a term internationally is usually the insolvency law. And that's what would you see also in DIFC, which is the offshore of Dubai, and the ADGM, which is the offshore of Abu Dhabi. So why do we have the insolvency law and the bankruptcy law in the UAE? The bankruptcy law, which I would have to name as law number 19 of 2019, bankruptcy law number 9 of 2016, and its latest amendments in 2020. And then the insolvency law, which was also passed as per what you see on my first slide here, 19 of 2019. So the insolvency law focuses on individuals and sole proprietorships, sole businesses. However, the bankruptcy law does apply to businesses in general, and except for those all over the UAE, except for those that are based in DIFC and ADGM. And that is mainly the exception to the bankruptcy law applicability. Next slide, Manu. You'll have to take us through this. The following slide, Manu, I don't want to really take a lot of time. I know everybody is squeezed for time in this short, roughly time limited. So let me take you through how to file for bankruptcy. The most important part of the 2 limbs of what I call the 2 limbs of the bankruptcy law, which are the preventive part of it and then the liquidation, is mainly the formal restructuring. We'll have to start with filing for bankruptcy. And the business culture now relies on businesses being honest about what they are facing to be able to be saved. So mainly, it's not something that you as a businessman would have to evade or just ignore. On the contrary, to help yourself, the first step, voluntarily file for bankruptcy. And that is supposed to happen within 30 days of becoming insolvent. Does that really mean that if you have a bounced check, does that really mean you are insolvent? Yes, indeed. That is the problem that we're having now, that people can actually report a bounced check if it has not been cleared within 30 days. So mainly the voluntary action here is your way of getting yourself out of trouble at the early stages. The preventive composition procedure, as per the law, is debtor-led, which mainly that they rely on the debtor himself or herself to take that action. And then it's court supervised. Most of the businessmen here know exactly how the courts work. We have experts, and usually experts are auditors, accountants. These are the people who will be mostly reliant on in terms of setting up what we are calling in the law the FRC, which is the Financial Restructuring Committee, that is mainly set up by the court to lead the preventive composition procedure. I think I'm done with this one. We're going to go to the bankruptcy procedures here, Manu, and proceedings as they are. So it's the application for the bankruptcy can be made by the debtor itself, the public prosecutor based on a complaint, the court itself, if there is a way that the court should be involved, and of course a creditor or group of creditors who hold an unpaid debt of not less than 100,000 dirhams. And that should be within the 30 days. Now, I would have to point out here in this slide that the latest amendments in 2020 have actually addressed the gap for the suspension of legal proceedings that was not available in the law of 2019. So Article 32 and 162, which are worth having a look at after we finish today's presentation, today's panel, they deal with the suspension of legal proceedings against the debtor following the adjudication of bankruptcy or the commencement of preventive composition. The amendment law addresses that gap that was so critical to be addressed. And I'm so glad to see it in 2020 because everybody was asking questions about it. And now we can clearly and comfortably say that under the amendment, the suspended time will be only until the ratification of the restructuring plan in bankruptcy proceedings, or ratification of the composition plan in preventive composition, or the lapse of 10 months from the date of commencement of the bankruptcy or the preventive composition proceedings. The court may extend at its own discretion this period by an additional 4 months. So these are very, very important points that mostly every businessman in this country should be aware of. Now, let me see if next one, Manu, please. What is preventive composition? I'll just go through the slide fast. A debtor is required to file for bankruptcy, as we said, within 40 days from the first due date. Alternatively, a debtor may apply for protection within that period. Whilst many of the criminal implications have now been repealed, luckily, a number of penalties apply to debtors who fail to take action within the prescribed period. And of course, I mentioned the 2020 amendments. Let's go to liquidation. A court can order the insolvent winding up of the business if, and in two conditions, in two situations, the liquidation will be applied and will be sanctioned. A preventive composition or restructuring scheme within bankruptcy is found inappropriate, not approved, or may be terminated. The other situation, the other condition, a debtor is acting in bad faith, and that is when immediately the court will decide and will rule on the business to be liquidated. What does liquidation mean? What is the aim of liquidation? The aim of liquidation is to terminate the corporate existence of the company, which really nobody wants for us. For businesses, for businessmen, for businesswomen that I've met throughout my practice, a business is like a child. It's literally, it becomes, there's an emotional bond, and nobody really wants a business, a corporate existence to be completely terminated. So this is why we are calling upon our clients and businessmen and businesswomen in this country to take that action voluntarily, not to end up in liquidation, and to watch out for when the preventive composition is or may be found inappropriate, may not be approved or terminated. A liquidation is undertaken by one or more court-appointed liquidators. Next, I won't take long, I won't take more, I promise, Manu. Manu is very, very strict with time, so he's been really watching over us. So what does liquidation mean for two important parties to our businesses usually? The creditors and, of course, the directors. Remember, the liquidation process itself is enduring, and the people who would be really impacted by it are not only the creditors, but the directors of the business. So the proceeds of the liquidation of assets are distributed to creditors pursuant to their ranking. And remember, always in law, there are priority creditors. Among them, like, immediately thinking of my head, employees, issues related to family sometimes. So these are among the priority creditors. Secured and preferred creditors with due and payable debts may obtain the court's approval to independently enforce their security against assets or debtors. Remember, every business would have those secured and preferred creditors. And otherwise, secured creditors will be paid out of the proceeds of the liquidation of the assets, subject to their security, of course. Directors, next, Manu. The directors, the failure to file for bankruptcy within the 30-day business day period no longer incurs criminal liability on the part of the directors, and that is what a relief is that for businesses and directors. The bankruptcy law introduces a regime for the disqualification and failure to file within the prescribed time frame may constitute a ground for disqualification of a creditor. So not the legislator in the UAE decided not to penalize the director by literally subjecting them to criminal liabilities. However, the penalty will be to disqualify them for up to 5 years, and that is quite a difficult penalty and a harsh one, in my opinion, and directors should really take it into consideration seriously. Now, the last, I'm not going to go through all the slides. I'm sure they're going to take much longer, but I will just briefly talk about the insolvency law, which is mainly, as we said, applicable to sole businesses, solely owned businesses and individuals. The term itself, insolvency, is used worldwide for bankruptcy laws, worldwide, even in the DIFC, even in the ADGM. However, for us in the UAE, the insolvency law has a different application, and mainly it is equivalent to the preventive composition of the UAE bankruptcy law. And the courts would expect the voluntary settlement can be only submitted by the debtor if the debtor is not yet insolvent. I will finish my presentation here. You can really wrap it up, Manu. And I thank everyone of our audience for being with us here today. If you have any questions, please do not hesitate. Address Manu with the questions, and I'm always there to answer any questions. Thank you.
Great. Thank you, ma'am. Thank you so much. It was a wonderful presentation. So even the time limit is there because we are covering a lot of subjects at a time. So even in case if one question, if anybody wants to ask now, I have 1 minute or 2 minutes time for that. So in case if anybody wants to ask, so I'll be happy to give that opportunity. So anyone?
I think just being the lawyer I am, I'm just so careful with my minutes Remember, I appear before courts in the UAE with right of audience. So I'm always conscious of the patience a judge has for me. And I always make sure that I try to leave before he gets so frustrated and tells me to stop arguing, counsel. Your time is over. So I think it's just a habit that I got from, from being the lawyer I am. So I have a question here from, what is the ability of general manager who is not a shareholder, but a salaried, sorry, I could not finish the question. Would you read it to me now? Okay,
What's the liability of general manager who is not a shareholder, but a salaried employee in case of company files for bankruptcy?
There is no impact of whatsoever on a general manager. The idea that, first of all, if you know how our trade licenses are, a manager that is already on the trade license is supposed to take that step on behalf of the company with, of course, consulting the directors to file for preventive composition with the court, try to settle with the debtors. So there is, of course, partly that responsibility. However, there is not a criminal liability on that general manager. However, the business will be the victim here and will be, of course, set for liquidation.
Okay, great, ma'am. That is very informative. And then thank you, Mr. Shailendra, for asking this question. So it is clear for everyone. So with this, I would like to close this session. Thank you, ma'am. We will meet again in the panel discussion. So now I am moving forward for the next session with the fourth speaker. It's also an interesting topic, very interesting topic that is also very relevant now. A new decision came by the ministry, that is none other than the beneficial owner procedure. What business owners should do now? I can see in the market, the business or the companies are running behind to know who's the actual beneficial owner now. The companies are running for years now. People are even the accounts department or even the people who are managing the company are running who's the actual beneficial owner. So very interesting topic. Let us hear it from an expert. The speaker is Nirav Shah. Nirav Shah is a chartered accountant by profession and rank holder in his academic records. He has specialized in international tax and finance and is advising on various cross-border transactions from international tax and domestic tax for last 2 decades. He is a regular speaker in different platforms in the UAE. Currently, he is a director at Fame Advisory DMCC. Dear Nirav sir, so the platform is yours. Please share your views on beneficial ownership procedures.
Yeah, Manu, thanks a lot for giving us this opportunity. And thank you to all the AAA committee member for giving us this opportunity to discuss this very important topic. Welcome everybody. Good morning. We are going through a marathon session of covering different regulations. And we have already seen the updates on the VAT law, the economic substance regulation, and we just heard Ms. Diana giving us an overview of insolvency, bankruptcy, and other parts of it. As part of the evolving process, as we have seen year 2020 to be, for UAE, the number of changes that it has brought about is unprecedented. And therefore, one more regulation which is now kind of got operational a couple of months back is in relation to Cabinet Resolution number 58, regulating the beneficial owners procedures. Now, this actually came into effect on 28th of August 2020, and it gave people about 2 months' time to file the regulations as per the law. However, this all regulation needs to be filed with respective licensing authority, and they in turn need to specify the method or mode in which they want to accept this information. So we'll go to the nitty-gritties of that. Basic objective of this regulation is to enhance transparency of entities which are registered in UAE, as well as to develop effective and sustainable executive and regulatory mechanisms and procedure in respect of the beneficial ownership data. So the idea is that the regulatory authority, which is registering a company, needs to know who the actual beneficial owner of that company or that activity is. And this resolution mandates this information to be collected by each registering authority from time to time. So there will be a one filing which one needs to do currently to comply with the procedure at the first stage. And then in case of any change, one needs to file that change within the 15 days and update the UBO data that the regulatory authority has. So it introduces new requirement to disclose where it is not mentioned very clearly to disclose its beneficial owners. Now, if you look at the scope, it applies to all entities licensed in UAE. So you may be licensed with any of the free zones or mainland or anywhere. All of them needs to comply with this regulation. Only exception being the entities which are directly or indirectly wholly owned by federal or local government, and entities which are registered in the financial free zones. Now, please understand that the exception given to the financial free zone authorities are only because they already have this regulations in place to make sure that they are aware of the UBO of the such structures which are established there. So they already have this data is what being claimed by those registrar, and therefore they have been exempted specifically from this requirement. But they anyway collect this data when you go to set up the entities with them, and those data are available with them and updated from time to time. Therefore, the requirement is to all the entities which are licensed needs to prepare and file an ultimate beneficial owner register, a nominee director register if applicable, and if it is not a corporate entity, then a partner or a shareholder register if that's the case. And all this needs to be with the relevant authority within 60 days from the date of this resolution coming in effect. And therefore, when we say that the resolution came in effect on 28th of August, the last date to file was actually 27th of October. What does we need to know? One needs to file with the regulatory authority the real beneficiary who owns or have right to vote having 25% or more shareholding of a company, whether through direct or indirect ownership or through control through any other means. So, or even they have right to appoint majority of directors, that also is thought to be control. So if no natural person can be identified, then the person who exercises control over the legal person through any other means will be regarded as a real beneficiary. And if you fail that test also, then the natural person who occupies a senior management office will be deemed as a real beneficiary owner. So these are the three criteria which is prescribed in the law. So, and if, for example, you have appointed somebody as a nominee director, and those are not acting to be a real director or not doing any real decision making, then those nominee director needs to file this register and mention that they are only holding this position as a nominee and they are not holding this position as a real director. Those information needs to be filed. And in case of partner and shareholder, number of ownership interests held by each partner, voting rights, and date of acquisition of this ownership interest. So please understand that this data remains with the registering authority. It's not that this data is going to be publicly accessible. It is only that this data will be shared with those authority only when it is requirement. And if somebody does not file this information, then the authority has right to impose certain administrative sanctions. Again, what to impose as a sanction? It could be a small penalty, or would it be, for some time the license will be frozen or anything like that. We don't know yet, but it is left at the discretion of the regulatory authority, and it's not mentioned in the resolution per se. And therefore, the key takeaway that we have from all of this requirement is that all entities in UAE must prepare this ultimate beneficial owner register, their nominee director information, and if shareholder or partner information. This needs to be filed with the registering authority. The date as per this regulation was 27th of October, but as we know, a lot of authorities were not ready to receive this information in time, and they have made this information they have shared the information with respective licensee of how they want to receive this information. So in case of some free zones, they came back and say that, okay, our portal will go live before say 31st of December. And once we have that, you can file it in there. The Minister of Economy said for all the mainland licenses, one needs to come back and file that information with the designated centers where you can go and physically give a copy of those filing to the person at the counter. So on and so forth. So each authority is going to ask you differently. But entity, and the second thing is, one is you have to file it now. And second is, one, you must notify the relevant authority of any changes or amendment within 15 days of such changes or amendment having taken place. So from that perspective, these are very, very important aspects that one needs to bear in mind, that one, we are now entering an era of compliance within the UAE spectrum. We have seen in last 2 to 3 years, VAT law being introduced, ESR being introduced, economic substance regulation, now UBO regulations have come. A lot of other Commercial Companies Act have been amended, insolvency and bankruptcy laws have come, and we are going to see few more changes which has come through in our remaining sections. So one needs to be aware that UAE is heading towards a direction of being more and more compliant economy. We need to be ready even for further more compliances. I will not be surprised if the corporate taxes will be introduced in some time as well. Therefore, businesses need to gear up and make sure that they are running properly compliant with all the requirements of all these changes in the laws as and when they are occurring. So I would urge all of you to take note of this and take care that these things are complied with in time. And thanks a lot once again for giving us opportunity to share these things. If you have any questions, please feel free to ask us at any point in time. Thanks a lot, Manuji. I hope I finished it within the time.
Yeah, you well finished within the time, sir. Even you kept 1 minute or 2 minutes for any questions. So even great. Thank you so much for that. So if anyone wants to ask at least one question, so you are welcome. Anyone is asking any question related to UBO? One question is there, Gopala Ravi. Mr. Gopala Ravi has asked. So can you see the question, Nirav sir? Or yes. UBO notification to be filed before 27th October 2020. We are DMCC registered company, but their portal has some software issues due to which we are unable to, or we are unable to file. Please advise how to address this.
Yes, Mr. Ravi, that is the case, but DMCC has made it mandatory that one needs to file this updated information through their portal only. And therefore, if any software issues are there, you need to ask DMCC of how best to resolve it. And you can file it once that portal goes live. As we have seen, not only with DMCC, but a lot of other free zones as well, that this deadline, while made mandatory in the law, one had time to accept this as per the regulatory authorities' convenience. So I'm sure the authorities will accept it as and when they are able to file and resolve this software issue.
That means we need not worry if the portal is not ready. We need not worry as of now. Just make sure that once it is ready.
Yes, that's right. And second thing is, even JABSA made sure we issued a communication as late as say a week or two back that they can file their portal to accept this information will go live only somewhere around 31st of December.
Yeah.
And therefore you need to file only when that portal goes live. So, and there are no penalties which are prescribed in the regulation.
Right.
So it is at the discretion of the regulatory authority, if at all, to levy such penalty. But if they are not themselves geared to take the information, I'm sure they'll not levy the penalty also.
Great. Very informative. So thank you for sharing that information. So thank you very much, sir. We learned a lot. So it is because a lot of authorities has given different deadlines, and then portal is not ready. That's confusing for many of us and business field. So thank you very much. So
thank you.
Now we are moving to the next speech. So great. So now, this is the topic which everyone is waiting. Everyone is having confusion. So this is one of the interesting topic for an expatriate forum like this. The topic is inspiring move, 100% ownership for foreign nationals. It is a landmark conversion in the UAE where increase in the FTA is anticipated. Yeah. So the speaker is Mr. Muhammad Al Shraide, founding and managing partner of Prime Case Legal Consultants. He has over 20 years of experience in the Middle East with extensive practical experience in commercial banking and Islamic finance litigation. He has a deep understanding of arbitration procedures and enforcement of arbitral awards within the UAE courts. He has successfully advised on and conducted litigation for many international clients and has extensive experience representing companies and high net worth individuals, whether in GCC or across MENA region. Dear Muhammad, IBPC is a platform, as I said, that for the expatriates. Most of the attendees are from that background itself. We are eagerly waiting to hear from you. The time is yours, sir. Please come and explain us. What are the latest updates?
Thank you very much, Manu, and thank you for having me in this session. And in fact, before I start this session and talk about this very hot topic, I just want to let you know that I have drafted like 15 pages or 20 pages that I wanted to share with you to discuss about this very important topic. But to be honest with you, in the last minute, and when I realized that the audience are businessmen and women, I decided to put these papers aside and talk about the practical consequences of this hot topic. Definitely, as you just mentioned, that everyone now in UAE is talking about this decree number 26 for 2020, which has amended the company's law number 5 for the year 2015. And in fact, this decree has amended and upgraded a lot, like 51 articles. But the most important articles that we are going to discuss today are articles 10 and 71, which talks about the 100% ownership for the expats or the foreigners in the companies. As you may all know, that before this decree, the 100% ownership was allowed for the foreigners in UAE under two forums. The first one is the Foreign Direct Investment Law, and the second one is definitely the free zone regulations. So in the past, the foreigners were not allowed to have more than 49% of the shares of any company in the mainland. But now, with this very significant amendment in the law, it has become eligible for the foreigners to have 100% of the company. But definitely, there are some restrictions. And I will not talk, by the way, I will not talk about the articles themselves, because definitely I will leave it for you to read them in the ledgers, and definitely you will have an access to all of these amendments in many places, because everyone now is talking about them, and everyone now is publishing these amendments. What I want today to emphasize is about the consequences of these amendments. And for me, as a lawyer, definitely, we care about the consequences of the laws, and we care about how the court perceive the amendments and apply those amendments in the courts. And definitely, as an investor or as a foreigner, you would need definitely to know how will the court will perceive and recognize those amendments. And this is the most, I think, part that you will be concerned about, because definitely we can have a lot of regulations, a lot of amendments, but we don't know how the court will perceive and apply these amendments, and whether these amendments are valid or invalid in front of the courts. Now, I will move actually to the other point of the discussion. As you know, or most of you may have had a company where you own 49% of a company, and you have definitely a 51% share to a national, Emirati national, definitely as per the laws. Because in the past, Article 10 of the company's law, it was, and it is mandatory, it says that it is mandatory to have 51% to an Emirati national. And Article 71 of the company's law says that no company or sole company can be established by one person who is not Emirati. So it was granted only for the Emirati national. But now, as everyone talks, that it's now applicable and it's now possible for a foreigner or for any investor, regardless whether national or non-national, to have or to own a one-person limited liability company. So what are the consequences of this? As I told you, that most of you or some of you have a company where you own, as I told you, where you own a 45% of the company, and the Emirati national has 51% of the company. But in reality, the ownership or the full ownership of the company might be for the foreigners. And this is a fact, by the way, and this is what we have in the actual life in this regard, because the investor had not able to own 100% of the company. He has to bring in a national Emirati with 51% of the company. So the consequences of this was the following. Actually, as you know, every shareholders may have a conflict, or a conflict might arise between the partners. These two partners, the 41% partner and the 51% partner, and in a certain point of time, they might have to go to the court with their conflict. So what was happening in the past, the foreigner or the investor goes to the court and submit a claim that the entire ownership of the company is for him, and the Emirati national is only a sponsor who gets a fixed amount sometimes against this sponsorship. And if the court found out ultimately that this was the case, the outcome is the court decides that, or to nullify or to cancel or to terminate or to wind up the company, because it is not allowed for the expat or for the foreigner to have or to hold 100% of the company. So when the court finds out the Emirati national has no actual or real shares in the company, definitely, and the expat has no right to own 100% of the shares. It orders or it adjudicates or it announces that the company must be wound up and liquidated, and because it cannot survive with 100% expat share. This was very important, very important. And I've seen a lot of cases where the court decided to wind up the case when it finds out that the national Emirati doesn't have actual shares in the company. And this amendment actually has completely solved this problem. So now, after the effectiveness date of this amendment or of this federal decree in January, 1st of January or 2nd of January 2021, I think, and it 100% will not be the case. So if the expat goes to the court with the similar case, and the court found out that the Emirati doesn't have actual shares in the company, the company will survive with 100% shares owned to the expat. And this is, I think, the most important amendment that has happened for the past couple of decades. And everyone, by the way, in the past was talking about this very hot topic. And I think now it is, a concern of everyone about the implementation of this amendment. And by the way, almost every day, I receive concerns, queries from a lot of companies, from a lot of clients, how this will be perceived by the court. Can we go now to the court to apply to the court that we own, or I own, the entire ownership of the company? Or what should I do? What should I do? The most important thing, by the way, here is we have to take into consideration that the law will be effective by 2nd of January 2021. So please don't do anything before that date. This is the effectiveness date of the decree. So anything will be done has to be done after this date. And you have to take into consideration that there is a 1 year given by the law for the companies to rectify themselves. And this part, I think, is very important thing, and very important part that the foreigners and the expat must look into very seriously, what they have to do after the effectiveness date of the decree. My tip to you and my advice to you, for the people or for the expat who already had entered into an agreement with an Emirati in a company for 49% of the shares, and it is not actual or doesn't reflect the actual shares between or among the parties, I urge them to rectify this during the 1 year that was given by the law or by this decree. How? You have definitely to discuss this matter with your Emirati national, that now the case has been changed and your presence definitely was mandatory by the law. And now, as long as the law gives the right to me as a foreigner to own the 100% of the shares of the company, we have to rectify this within 1 year. If definitely both parties agree on this, I don't think that there is any conflict or dispute will arise in this regard, because definitely they both have to amend the article of association, and it will be announced and published, and no conflicts will be rising. But what if the partner, or what if the Emirati national who holds or who carries 51% of the shares, and he declined or he rejected to get into this consent or to this agreement with you? I think that definitely if you reach a dead end with in this discussion, you have to go to the court. You have to resort to the court, which is the forum that will settle this dispute, and to apply to the court with a case that you own the 100% of the shares of the company. And if you have an agreement, if you manage to prove your case, definitely the court will announce that you have the 100% shares of the company. And there is very important part, or very important thing here. I think the foreigners have to have, or had to have, an agreement or a shareholder agreement between the parties that stipulates the actual shares between the parties, and the percentage of the dividend between the parties. And if they have enough pieces of evidences and the proofs, written proofs, that they own the company, they will manage to obtain a favorable judgment in front of the court. So it's very important for every expert or foreigners to have an agreement that stipulates or illustrates its rights with the other partners. And now the other concern is for the investor who did not have this mechanism or this structure in the companies, and they now want to establish a new company, as long as this decree gives them the right to own 100% of the shares of the company. They have definitely the right as with the law, but they have to take it that there is a very important thing they need to consider also. Again, you don't need to do anything for now unless the strategic impact list comes by the cabinet, because as you know, the article 10 of the law removes definitely the 51% of the shares, and article 71 definitely gives you the right to establish a company that you can own 100% of its shares. But definitely there is now a list of the strategic impact activities that will be published. So before this has been issued, I think it's premature to go or start to establish any company, because this list will identify the strategic activities list is that you can own 100% of the companies that have those objectives, and the companies that you are not allowed to own 100% of its shares, like definitely the oil and gas activities, transportation, insurance. So we have to wait a little bit until this list has been issued. I'm sorry, I think there is a lot can be said in this regard. There are a lot of debatable discussion or debatable questions that might be discussed, but I think the time for this session is very limited. So I'm sorry to finish because Manu now is is I think he's conscious that I have to finish this part. So thank you very much for listening for me.
Thank you very much, Mr. Muhammad. So very informative session because this is a topic very everybody is having many questions, and the law itself is it needs little more time us to take a decision, as you said, and it will not be a easy work. So it will be a lot of litigation will be there because as of now 49-51% is a legal structure of the company. Whether it is going when we form a company in future, it is possible under percentage, but for existing, this is a legal structure, right? Structure. So restructuring it, everybody's permission is required. All the shareholders' permission is required, right? So that's a big information for us. Thank you for sharing that one. Now we are going forward to an interesting topic. Whenever we sit at home, sometimes we listen neighbors as well. So that is our habit. So how we can leave our neighbor? So this is an interesting topic from the neighbor country. So the neighbor country is Oman. So Oman also going to implement VAT. Let us hear from an expert speaker on the same subject. So the speaker is Deepak Agarwal, a chartered accountant by profession and associate partner with the WTS Dubai UAE. He is handling indirect tax and economic substance regulation matters. He has over 16 years of post-qualification experience in serving large multinational and SME clients on indirect tax matters. He is an avid speaker on various indirect tax topics and has also written technical articles and research papers in indirect taxes with a successful outcome. Hi, Deepak sir. You are welcome to take it forward. Hope you can share your screen.
Yes, thanks, Manu. Just a second, I'll share my screen. Perfect. Thank you so much, Manu. Thank you, IBPC, for this opportunity. You know, before I start, you said interesting topic, and it's generally very difficult to explain or understand taxes when it's the last topic of the workshop. But I'll try and do justice and keep the discussion really short and informative rather than really getting into technical bits. So what I plan to do is just talk about what has been happening generally in VAT in GCC. Then talk about Oman, how Oman is looking at VAT and some provisions that specifically KSA has introduced in the last few months. Right. So quickly from a GCC VAT perspective, so I'm sure people would be aware, it's somewhere around 2008 that these 6 GCC countries came together and decided to implement VAT. And it was only in November 2016 that the GCC framework agreement got executed. And post that, KSA and UAE were the first 2 countries to introduce VAT from 1st January 2018, post which Bahrain implemented on 1st January 2019. And very recently on 18th October 2020, Oman issued its VAT law and specified that it would implement VAT. More from the other 2 countries which are still left behind, Kuwait and Qatar, there is yet no confirmed news in terms of when these countries would implement VAT. 21 looks to be a challenge, potentially 22. And again, more from an Oman perspective, it says the date could be around 16th of April. Before I move to the next slide in terms of how Oman is going to do the implementation, KSA has this year introduced a few changes. And to highlight them, very recently, KSA is looking at mandatorily implement e-invoicing, and they've given 1 year to businesses to implement this. There is a detailed regulation decree around this, and there are guides available as well. So businesses need to start looking at this change as well. The other 2 were, KSA implemented the real estate transaction tax, which essentially replaced the 5% VAT effective 4th October 2020. There are other, modalities around this. What happens to the VAT if it's already been paid but the property is not got transferred? What happens to the VAT that I incur but I finally end up paying the real estate transaction tax? So there are things that people need to keep in mind. The last is around rate change. I'm sure people would be aware. 15% is what KSA has increased the rate. Just from the other countries' perspective, there was a lot of noise around whether UAE would be increasing the UAE VAT law, and even from Oman as well. But what we've been hearing from the authorities and the government is there is no hurry in terms of UAE or UAE looking at increasing the rate of VAT. But from our general experience, I wouldn't be surprised if in the next 1 or 2 years UAE also looks at increasing the VAT rate. Now, in terms of the timelines for Oman implementation, the slide is pretty self-explanatory, but just to take you all through, 18th October is when the decree was, pronounced, and the decree said that the VAT would be implemented within 180 days of the issuance of this decree. So that's where, the 16th April comes into play. The regulations is the next steps. The law is in place. We expect the regulations to be somewhere in December. In fact, I was speaking to a person today morning, and he confirmed that potentially next week or the 3rd week of December is when the regulations could be out. The VAT registration process, again, it's going to be an online process, which is going to get kickstarted from January 2021. Just one point here, what we've been hearing is Oman may look at implementing something what Bahrain did, and not, enforce registration for all the companies that are there in Oman. So there will be a potential threshold above which, if you have a turnover, then you need to register. But this is something we've been hearing, and the regulations need to confirm this. 16th April 2021 is the VAT go live date. That's when businesses need to be ready with their systems, with their tax treatment, etc. I'll take you all through what businesses essentially need to do from a VAT perspective. The last bit is around the VAT periodic return filing compliances. So again, we've heard that Oman is going to have a quarterly return filing for all businesses for the first year or somewhere. So again, the first return could essentially come into August, but this is something which needs to be coming into the regulation. So it could be either May or potentially August. Now, Oman VAT, a snapshot, very, very busy slide. I wouldn't, take you all through everything, but I just thought I'll just highlight the differences that are there in Oman VAT law vis-a-vis UAE, Bahrain, or KSA. The first is around VAT treatment. Specifically, Oman is looking at exempting education and healthcare, whereas in the other countries it is zero rated, which essentially means there will be no input tax recovery for such businesses, and potentially increase in the value of such services, cost of such services for the consumers. The other is around zero rating, very similar to other countries, except for the fact that specific transactions around services relating to goods, repairs, maintenance, where the goods are located. So, UAE specifically says where the goods are brought into UAE for, let's say, repair or refurbishment, it will not qualify as export. Whereas Oman has treated this differently, and they're saying this would be a zero rate transaction. Out of scope supplies, this is something which, the law does not really have jurisdiction to tax such transactions. One thing which is specifically mentioned here is around the insurance claims a business makes. So, typically when you get a policy, you pay a premium, and once you make a claim, the insurance company makes payment of the insurance claim to you. So the Oman VAT law specifically says, insurance claims paid by insurance company to a business will be out of scope. The other is around place of supply. The point I wanted to highlight in place of supply was generally across globe, the concept of place of supply is essentially to look at VAT as a consumption tax. Where is the actual consumption happening? So Oman is the first country. I look at the other four as well, three as well. This is the country which is actually looking at the concept of consumption tax, and they've said that place of supply would be related to where the customer is located. Transitional provision, it's very similar to UAE. I just wanted to highlight this because the date of implementation in Oman is 16th April. So the way UAE looked at it for all the transitional supplies, so where you raise the invoice, you receive the money before the date of implementation, but the supplies were made after implementation, the point of taxation is 16th April. So you need to pay the tax for all such transitional supplies with your first VAT return. The next, VAT return and payment, it's going to be online, very similar. Just the point I wanted to highlight is the date. So the Oman law talks about 30 days from the end of a tax period. Now, this is very peculiar. Again, if you look at UAE and KSA, so UAE says 28th day of the tax period, next month of the tax period. KSA says the last day of the next month. So Oman says 30 days from the end of your tax period. So, typically, let's say if it's a January where there are 31 days, your, tax filing period date or the tax payment date would be 1st of March. So that's something we'll have to be careful in terms of the compliances. The last two, tax disputes and penalty, I thought I should bring this up, and it's very interesting and heartening to see, Oman has been a bit liberal in terms of the disputes and the penalties. So why I say liberal is tax disputes. If you look at UAE, Ankur had mentioned earlier that the Supreme Court has just said that you need to pay the 300% penalty once you file a VD. So Bahrain, in a way, has given a liberty, or there are provisions for businesses to file a stay petition. So the way it works in UAE is, if you have to file an appeal to the TDRC, you need to make the complete tax payment with the TDRC before you invoke your right of appealing. But in Bahrain, in Oman, the way they are looking at is, if you want to dispute it, you can file two appeals. One is at the principal level to challenge the taxability itself, and the second is to ask for a stay so that you don't have to pay the tax immediately. So only when the final appeal gets heard, depending on which way the case goes, there'll be a tax liability to deposit. Penalties, again, is very interesting. If you look at UAE, KSA, or Bahrain, the penalties are very steep. UAE is 300%, but surprisingly, Oman has really, so Oman has bifurcated these penalties into two. One is where there's an intent, so there's some deliberate, mind involved in terms of committing a particular non-compliance. So that's where there are some penalties, but again, compared to UAE and KSA, the penalties are not that steep. And if there is, let's say, a short payment because of XYZ reason where there is no malified or deliberate intent, the penalty is restricted to 1% of the unpaid tax amount. And so that's very interesting. So if I look at an annual penalty, it works out to around 12%. And compared to UAE, which is 300%, Oman has been very liberal in terms of penalties as well. So what businesses need to do, I wouldn't really spend a lot of time on this, and I'm sure people who've got businesses across UAE, KSA, Bahrain, and Oman would have gone through this process. But for people who are having businesses only in Oman, I'm sure you would be aware there needs to be a typical implementation project that you need to start, and I'm sure you need to start it very soon. Similar to UAE, people should not really wait for the regulations to come out, and I'm sure there's enough from the UAE, KSA, Bahrain VAT law that can be used for implementation. So quickly, you need to start, creating awareness within your organization in terms of how VAT is going to impact you. What are the potential implications of VAT when Oman introduces VAT? You need to do a VAT impact assessment in terms of mapping your transactions, both revenue and expenses, and seeing what are the impact from a VAT perspective. Again, systems would be impacted. Nothing much to discuss on this. It's an obvious one. Contract reviews comes these transitional provisions, obviously, where there are tax clauses, whether the price is inclusive, exclusive. Training and compliance framework is essentially having an in-house team potentially to see how will your compliances work. Is the team will the team be geared up to pick up the compliances in-house? And the last bit is start complying, as I said, potentially from May or August. So so that's around GCC or VAT and Oman specifically. But I think where we are heading to is a lot of changes have been implemented, as Neeraj Nirav mentioned, Mohammed mentioned, Diana mentioned, there are a lot of changes coming around in various countries. GCC, CBCR is one which is, getting a lot of traction. I'm sure transfer pricing will pick up very soon. I think Nirav mentioned, potentially these things, for example, the ESR or CBCR, transfer pricing, these are all precursor to a corporate tax. So I wouldn't, obviously there has been a lot of noise around whether corporate tax will get implemented or not, but the way things are moving in UAE, and if you just, look at things in perspective, yes, corporate tax could be at the anvil. I really don't see there could be a personal tax because of obvious reasons. UAE thrives on expats, so essentially from people who come from outside UAE. So Manu, that's all from my end. I hope I have been able to meet my time. Thank you so much.
Right. Thank you, Deepak. Thank you so much. It was very informative. So you briefed and then you gave an overall perspective of the other regulations which is happening in GCC as well. So now we had a series of topics to discuss, and then we finished all the 6 topics. So even now, the very interesting session we are going to enter, that is panel discussion with eminent 4 speakers sharing their views on an interesting topic. Every individual is waiting to listen from them. The topic is new changes in the law affecting social life in the UAE, covering inheritance law, marriage law, fine on public indecency, attempt to suicide, consensual sex, and etc. There are 4 speakers in the panel, as I said, Ms. Diana Hamadi, Mr. Naveen Sharma, Mr. Mohammed Al-Shraide, and Ms. Nada Al-Khurer. So 2 speakers, Ms. Nayada Hamadi and Mr. Mohammed Al-Shraide, were already introduced and spoken to you. Let me introduce the other 2 speakers. Ms. Nada Al-Khurer is an associate lawyer at Diana Hamadi attorney at law since 2020. Ms. Nada graduated with LLB from Middlesex University in London. She worked in DFSA as a paralegal to assist the legal team on compliance of UAE law regulatory issues. She is currently studying for the New York bar qualification. Ms. Nada writes a column in Villa 88 named a UAE Generation Z. Wow, I've seen that. You might have seen that one. In fact, I read it. Very informative and interesting. So that is the first one of the speakers in the panel discussion, and the other speaker is none other than Naveen Sharma. Mr. Naveen Sharma doesn't need an introduction in IBPC platform at all. Still, it's my responsibility to introduce him since there are many guests in our in this session now. So he is a convener of accounting, auditing, and advisory, that is a AAA focus group of IBPC Dubai. He is a multi-talented professional, a chartered accountant by profession, and currently the director internal audits in IASIS investment company Al-Shirawi Group. He is the past chairman of ICA Dubai chapter as well. He doesn't need any more introduction. He is very familiar to this platform. So with this, I invite all panelists to come forward for handling this session, for answering this session. So I'm going to, I invite all the speakers to come forward, unmute yourself when the round comes to you. So I will try to balance the time. I plan to have a 30-minute session. So now we may be a little bit late to close the session, maybe 10 to 15 minutes time. So hope within 20-25 minutes, we can conclude this part, but very interesting subject. So I'd like to ask the question to Ms. Nada first. Madam, the United Arab Emirates is abolishing lenient sentences for so-called honor killing, loosening alcohol restrictions, and lessening the sway of Islamic over foreigners. What do you believe triggers such amendments? Can you just give your view behind that?
Hi, everyone. Firstly, I just want to thank Manu for this opportunity. I appreciate you reaching out to us and having us to be joining you on this panel. So regarding the question, the mentioned amendments shared initially on social media platforms and the media are mainly introduced through the Federal Decree Law number 15 of 2020, amending some provisions of the Penal Code issued by Federal Law number 3, 1987, which was partly based on Sharia and has not been amended ever since. The 90% of the 10 million people living in the UAE are foreigners, and the UAE community received the amendments with relief since the amendments were needed to be issued to enhance the legislative foundations in line with the country's commitment to and believe in tolerance principles that are in accordance with the UAE's cultural identity, to boost its status and capability as one of the world's most attractive destinations socially and economically for foreign expertise and investments.
Okay, great, ma'am. So what I would like to hear from Ms. Diana regarding this one is, how did this amendments protect women? Because that is very interesting for us to hear, because of the importance what normally UAE is giving to women. So I'd like to hear it from you, how it will protect the women specifically.
So the light sentences.
Some echoes coming, yeah.
Okay. So the light sentences that are eliminating the so-called honor crimes is one of the most recognized ones. Although I have to say, there is another provision in the Penal Code that does provide what we call mitigating circumstances in another circumstances. So the idea that the honor killings are completely wiped off the face of earth, as far as we're concerned in the UAE, is a relief for women. The other thing that I may say that, honestly, sexual harassment is an issue that women suffer and face, not only in the UAE, all over the Arab world and mostly Southeast Asia. So we have to recognize that we have issues that women are suffering of, and they're not really addressed necessarily by the legislator in most countries in a proper way. Now in the UAE, the maximum fine has been increased to 100,000 dirhams, and a 1-year jail term is stated by the law for those who violate the defined sexual harassment. So if a woman is assaulted in a public or frequented place, if a male is disguised in a female apparel, both actions will subject the offender to the mentioned sanctions.
Okay, great, man. So that is a great relief which we are going to have because of this regulation. So let us get the benefit to the community soon. So with that, I would like to move to the third speaker, that is Mr. Mohammed. Mr. Mohammed, some people have received the news of UAE's amendments of criminal law with bit of confusion. So there's confusion, and they think that the government has gone lenient on sexual crimes. So how do you evaluate this theory from the legal point of view? Because when this kind of news comes, then even in the social media spreads a lot of wrong news as well. So people might have understood it as something wrong way. So in this platform, can you just share what is the legal point of view? What is the actual proposal related to this?
Anyway, first we have to distinguish actually between the acts which are deems crimes by nature and acts which don't consist a crime per se, but legislations, whether illegal or religious, have criminalized them for other definitely social benefits. I will give you an example for this. Murder is considered a crime in every religion, law, and personal sentiment. It is a crime that causes loss of a human life, loss of beloved person to many others, and loss of a productive member in the society. This is a natural climb. But for example, in the other side, smuggling clothes through customs, on the other hand, is not harmful act by nature, but for other reasons or grounds, might be economic or other reasons. The legislator has criminalized it for the greater benefit of the society. This so it became a legal crime rather than a natural crime such as the murder. And the short answer to that amendment to the penal code have exempted acts of personal freedom which cause no harm to others from punishment, while it has actually increased punishment for crimes which cause harm to others. For example, rape definition has expanded to include intercourse with mentally challenged people who are unable to give consent. So the amendment is taking consideration and taking into account the personal freedom and also the harm itself, whether the action does harm others or not. And we have to understand that UAE has more than 200 nationalities. It's a mixture of cultures and nationalities, and the laws and the regulation in UAE has to address and has to respond to this very important part.
Right. So very informative. With the same, I would like to move to Mr. Naveen Sharma. Mr. Naveen is an expert in finance and business. He might be having a different view on expected changes happening on the changes in social life. So, Mr. Naveen, what are the most noted amendments for the business community for ease of doing business by you? Can you just have a little lights on it?
Thank you, Mr. Manu. I will give you the broad perspective, and I can see that the speaker after speaker, panelist after panelist, has shared in-depth knowledge about the provision. Okay. Now, I will say what Mr. Muhammad had said just now. The ease of doing business in the UAE has changed drastically, as the attendees and the panelists and everybody is aware. Ease of doing business is the yardstick which is used globally. The UAE is now 11. It has moved. It was 10 years back, it was more than 50. Today, it's 11. Now, when the ease of doing business has changed and become more in line with the international level, then, and this, by the way, the 11, there is no other country near to us. Even Saudi Arabia, we have 63 and 62. So as far as the UAE concerned, it's way ahead than the regionally and in Asia as well. Now, but in the social side, there were hardly any reforms in the last 10-15 years. As the co-panelists said, that UAE is moving internationally. They are paying attention what is required and how we can cover. So they have changed the inheritance law. That is the key, because 200 countries citizens are living in this city and the UAE. And if people don't change and give them the inheritance law, you cannot have the investment. Similarly, you can say the honor killing is clearly now defined. Even the victim's privacy has come out with the law. So the social law which we have changed, it is in line with what the UAE as a business reputation is attracting the people. Today, people from all over the world are coming and investing in this part of the world. So it is required to change the social fabric and structure. At the same time, keeping the core values intact. I think this is the welcome change overdue, and I feel it will give a peace of mind to the people living in the country.
Great, Naveen. Yeah. So let us take it in a positive way to have it happen soon. So I would like to go back to Ms. Nada once again. Ms. Nada, social laws which which we are discussing here now, have they been expected to soon? So, what's your view on it? You have any information related to that one? And if so, how do you expect them to implement in practice? Won't there be a lot of challenges to implement such changes in the country like UAE?
There might be some challenges in implementing it because it came as a shock to the majority that how fast these changes, the laws have changed. But in my opinion, the most noted amendments are firstly the diminishing of the role of the Islamic codes in the UAE justice system. So that's a big change for our country. And secondly, the loosened regulations on alcohol consumptions, which provides that there will be no punishment anymore for anyone that consumes or has possession or trades in alcoholic beverages in cases where they weren't permitted under the legislation. Okay. The regulatory will come later. The laws in place will be published soon. We don't have the actual laws yet.
Yes, now I'd like to go to Ms. Diana. Madam, UAE is a country where more than 85% are expatriates, nearly 88% are expatriates. What do the changes to the laws on inheritance mean for expatriates in the UAE? So it is a very interesting topic for expatriates on inheritance. So can you just highlight related to that one?
Up until now, if an expatriate died in the UAE without a DIFC or ADJD, and ADJD is the Abu Dhabi Judicial Department, the family of the deceased would have to find itself at the courts with the deceased assets divided as per Sharia law. And don't tell me otherwise. No matter how many people claim that they had the notarized wills, going to court was just the test for those notarized wills, and they did not succeed at getting these expats what they expected of applying their foreign laws unless they reached the stage of the Court of Cassation or the Supreme Court. That was expensive, that was excruciating, and now I have to say, although we had in the personal status law a way to apply foreign laws throughout, the wills of the DIFC and the ADJD were the only way to have it confirmed. The DIFC has a probate court, which is an English court with a properly structured probate court, and the ADJD does use the Abu Dhabi court, Abu Dhabi ADJD court for these wills. And they have been a smooth operation, a very effective one, and they have proven to be the way out of it. Now, the law now, 30/2020, is saying simply, a deceased expat in the UAE will have their laws applied, which means forced heirship. What is forced heirship? It is the laws that are already in every country where there is already a distribution of assets as per the law. How effective that would be, how difficult that would be to apply a foreign law, which is not always an easy way to do things in the courts here locally, I will leave that aside. Now, the other provision states that if there is a will that has been entered if there is a will entered by the deceased before the death, it will be applied, it will be governed in a way under the law of the deceased or the law of the will. Okay. Then the UAE assets will not be included and they will still be subject to UAE law. Okay, that's confusing. To me, as a lawyer and as an advice to everyone here, we only have 83 people out of the 120 that we had earlier. Obviously, people have other things to do on Saturday, but to everyone, I would say, your best option here is to have a will drafted in the UAE, either in the DIFC or ADJD. The problem with the ADJD wills are that they will have to be drafted in Arabic and then translated into English, which is always a challenge because there's a lot lost in translation. The law is required, the amendments comprehensive, but in application, that would be my advice.
Okay, great. So we had to go for that will. Yeah. So everybody is thought that immediately we can go with the new new regulation. So okay, time is there. Time. Yeah, will is very important. So thank you, ma'am. Thank you so much for that wonderful information. So very informative and yeah. Let me go back to Mr. Naveen once again. Mr. Naveen, we are discussing earlier how this changes will help the business to grow in the UAE. I would like to ask you how it will affect the life of the people in general, since UAE is a home for more than 200 nationals, where the rule comes liberal from this aspects. How people will accept the changes? What's your view on it?
My view is that these changes are overdue because we are part of now the global society. The UAE is nothing but a miniature version of the world where 200 plus communities are living side by side. And this is one of the best city to have start your own business. And ease of doing business, as I said, is 11. But the challenge is last year, it has decreased. This year, sorry, my mistake, my apology, it is 16. And last year it was 2011. So last year it was 11, now it is 16. So we have slipped because other countries are also putting a lot of efforts to improve and making sure they compete. So there is a global competition to attract the FDI and people are living well. So if you will give the people who are living here the ease of leading their lives, they have the inheritance law, they have the small changes which are being made here, that will make their life more comfortable, they will be more long term, and whatever the up and down which is happening extremely in the UAE economy will also be less. So as an economy we are moving towards this service economy or knowledge based economy, I think these law will be beneficial to us and people will be more happy and there will be a growth in this society and especially economy will boom. So this is overdue. It is helpful to have these laws and people will now can see that how they can plan their inheritance, not only in the business, but in their properties, in their will, there is a clarity. So I'm very happy that these changes have been made and there may be something which is ahead of the time, but I think we are moving and integrating ourselves with the rest of the advanced economies in the world.
Right. That is right, Mr. Naveen. So, the changes are happening a lot, and then we are moving forward itself. And then, Miss Nada, I'd like to come back to you once again. I would like to ask you the what law governs marriages and divorces of expats in the UAE subject to the new amendments? Can you just throw lights on it?
Sure. Federal Decree Law number 30 of 2020 amended the Federal Law number 5 of 1985, which issues the civil transaction law in relation to marriage and divorce, provides in Article 12, Sub-Article 1, that the substantive conditions for the validity of a marriage shall be governed by the law of the state where the marriage took place. So wherever the parties got married, the law of that country or the place wherever they got married will be implemented upon divorce. It's not very different, in my opinion, from the provision in the Personal Status Law 28, 2005, where the law of the party who asks for their law to be applied, but is now rendered repealed, following Article 2 of Law 30 of 2020, which provides that any provision contrary to or in conflict with the provision of this law will be repealed. In Article 13, it also states that the law of the marriage shall be applied to the personal and financial effects resulting from the contract of the marriage, and that divorce or separation shall be governed by the law of the state where the marriage was contracted. And I guess that's it. Do you have any other questions?
No, I'll go back to Ms. Diana now. So this is very important also. How will divorce become international under the newly amended laws, ma'am? Can you just, how it is your view? Because a lot of concerns are there for the people. So even though I don't think
the
that—
question, Manu?
Yeah, how the diverse is one of the concerns always having people are having very difficulty while managing that one. So how this new regulation, how it will help, how this international, how it becomes international by newly amended laws, how it will be really going to manage.
So the idea here in the UAE is that because we have such an expat community in big numbers, we will have to provide them with the laws that they are familiar with. We cannot just provide a legislative system that is based on our religion, on our law, and have people subjected to it, especially when they come from different parts of the world with different legal systems. The evolvement of the law of the UAE now is to mainly address the expats with the laws that they need. The most needed ones have always been, beside the business part of it, beside the penal code, which was always like the decriminalizing of alcohol, the cohabitation, all of that stuff. Now, the other two parts of the law that were always a huge concern for the expat community was the inheritance and the divorce. The divorce under Sharia is not for everyone. It's not suitable for people who come from the UK, the common law jurisdictions where a woman can share half of the assets of a husband upon divorce. The Southeast Asia, where some of the countries still do follow certain religions, like based on religion, the divorce laws of these countries. So now we are telling people, you want the law, it's not going to be the party's law anymore, it's going to be the law of the marriage. I don't know how that would actually apply itself.
Yeah.
I always thought, and I always say, that the courts in the UAE need some qualified, not necessarily qualified in the sense that our judges are not qualified, but they will need a new generation of judges that really can apply these foreign laws. It's not easy. We've tried it for the last 45 years with the judges that we had. Some of them are younger, some of them are coming on board, but to ask a judge to apply a foreign law is a lot of work. And that would require certain qualified judges to be able to do it. And I will just conclude with that. Thank you, Manu.
Okay, thank you, ma'am. And I'll go back to Mr. Mohammed. Mohammed, you can hear me now? Earlier it was, you had some issues, technical issues. You can hear us now?
Of course, yeah, I can hear you.
Okay. I don't know whether you got my question, which I asked you. I'll repeat the question once again if you didn't hear it earlier. The amendments which we already discussed, how would this amendments affect people serving time in prison for having had consensual sex or similar to that, or those being investigated when the amendments were issued? So how already people are facing that serving time in the prison. So how it will be handled in once the laws getting implemented?
This is a very nice, very good question. In fact, UAE has adopted a very good rule in this, in its criminal law. It is the rule which stipulates that as an exception to the instant effect of laws in general, criminal laws in particular are applied with a retroactive effect only if the new rule would benefit the suspect or the convicted person more than the superseded one. This was expressed particularly in Article 13 of the Penal Code and in Article 246 of the UAE Criminal Procedures Law, and in multiple precedents of the Court of Cassation. So, any suspect who has been investigated for a crime which has been removed by a new law, the investigation shall be ceased and the accusation shall be dropped accordingly. So, in case there is a final or conclusive verdict regarding such a crime, the impact of such verdict shall cease to exist. So according to Article 13 of the Penal Code and according to the many of the cassation precedents. This is my answer in a nutshell.
Yeah, okay. So because we are having short of time, so thank you for concluding that one on fast track. So my last question to Mr. Naveen. Naveen, you are available, no? Your camera is not visible. So are you there? Yeah.
Yes,
So
I'm there.
just, if you can wind up the question in 1 or 2 minutes. The my point is that how those changes will help legal and finance professionals who are in practice in UAE in general, because a lot of changes are happening in economics and legals and all aspects, finance and also. So how it will help, what is the role of not only helping them, I mean that what is the responsibility of those professionals?
See, I think this is the best question. Now you can see the record attendance today, because everybody wants to know about the laws, its implication, and how it is going to affect. 5 years down the line, we were not aware about most of the law. Today, we want to know about the law, because in this country, we want to follow the law. So now the law has come, clarification has come, and you can see I know that mostly are chartered accountant, and there is a new breed of CAs, lawyers, and other professionals have come who are expert. And they are not only doing practice in the UAE. Today we had a session in Oman. Deepak spoke so brilliantly about the Oman, because we are part of the interconnected world, where not only the UAE, but the neighboring countries, we want to know the law. Now the transfer pricing, you spoke about the ESR. ESR is nothing but a transfer pricing and the OECD regulation which are coming. So as I said, we are part of a one global society. The laws are coming which are global in nature. We need the expert. We need the people who can make sense and explain, like Madam Diana and Madam Nada and Mr. Mohammed have explained the legal side in a very, very simple way. I become so knowledgeable. So if we don't have these people, we will not be able to understand. So it's very important that we know the law, its provisions, and follow. I think it's going to help not only the business, it is going to help the professional as well. So I can see a bright future. I know Mr. Manu is a part of the steering committee, but I have seen him sharing the knowledge during the VAT time, going to the radios. Today we have a radio program which is dedicated what is coming as far as the law is concerned. So I can see sometime you will see a TV debates coming up. So we have a good framework where the professionals will share their opinion. We will make the business more accountable, and globally people will think that UAE has a legal system which is working and it is in line with what is happening in the rest of the world. So I can see a very good time for the business as well as the professionals in this part of the world, and we can see the changes which is happening today.
Great, Naveen, sir. Great. And so that's a very, yeah. Please proceed.
Just one thing, as we are overshooting the time, so as a convener of the AAA, means I can say that we're hardly any time to take the audience question, and so if you feel like after some time you can invite for our CG to give the vote of thanks.
Yeah, I will. I'm just going to conclude the session. So thank you so much for giving that, sharing your view. So thank you, Miss Diana Hamadi and Mr. Muhammad Al Shraidi, Miss Nada Al Khureir, and thank you, Mr. Naveen Sharma, for sharing your views on this latest updates, which was very relevant for us to know today. So in short span of time, we have learned a lot of things. So now here, this is the last part of the session. Nothing more for me to share. I'm very happy. I'm honored for giving this opportunity. The only way that we can grow is if we change. The only way we can change is if we learn. And the only way we can learn is if we are exposed. And the only way we can become exposed is if we throw ourselves out into the open. Do it. Throw yourself. So with this note, I would like to hand over to Mr. Dilip Sinha, the Secretary General of IBPC, for for closing remarks. Have a
Thank
blessed
you,
day.
Manu.
Stay safe. Stay healthy.
Thank you, Manu.
Good evening.
Thank you,
Salam
Manu.
alaikum and namaste, everyone. At a time when the whole world is battling with COVID, UAE government has come out with groundbreaking and innovative economical and legal reforms, thanks to the visionary leadership of UAE rulers. On behalf of IBPC, I would like to thank our esteemed and distinguished speakers and panelists for clarifying key aspects of both legal and economic reforms that has come in our way. It has really been an enlightening session, and I'm sure all the members and guests have benefited immensely from it. Also, a word of appreciation for Mr. Naveen Sharma for a great initiative by AAA Focus Group in organizing this very relevant topic webinar, and also a very enthusiastic moderation by Mr. Manu. Thank you all, guests and members, for attending today. Wish you all a good day and see you soon. Thank you.